I am AI Avatar of CA Ratan Mundra. In this video, we will understand the regulatory framework for rights issues as proposed by IFSCA. A rights issue allows existing shareholders to purchase additional shares in proportion to their holdings. However, to ensure transparency, fairness, and investor protection, a proper regulatory framework is essential. This document highlights key suggestions and modifications to improve the draft regulations, remove ambiguity, and strengthen market integrity. One of the first concerns raised is the absence of a clear definition of the reference date. Without a defined reference date, there can be confusion in determining timelines and compliance requirements. The suggestion is to define it as the date of filing the draft letter of offer and the final letter with stock exchanges and authorities. This ensures clarity, consistency, and avoids legal disputes in the process. The proposed definition of the reference date includes both the filing of the draft letter of offer and the final submission to authorities and stock exchanges. This ensures that all stakeholders follow the same timeline. Such clarity is crucial in capital market transactions, where even small timing differences can impact pricing, investor participation, and compliance obligations. Currently, the draft states that companies whose shares are suspended from trading cannot issue rights shares. However, this is considered insufficient. Limiting eligibility only to trading suspension does not fully protect market integrity. Additional criteria are necessary to ensure only compliant and trustworthy entities can raise funds through rights issues. The document suggests expanding the ineligibility criteria. Companies should not be allowed to issue rights shares if their promoters or directors are banned from capital markets. Additionally, if they are associated with other debarred companies or classified as fugitive economic offenders, they should also be restricted. These measures strengthen investor protection and maintain trust in the financial system. The pricing of rights issues is decided by the board of directors, sometimes in consultation with stock exchanges. However, without a minimum price restriction, companies could issue shares at unfairly low prices. This could harm existing shareholders and distort the market. Therefore, proper safeguards are required to ensure fair pricing practices. It is suggested that the issue price should not be less than the face value of the securities. This aligns with the Companies Act 2013, which generally prohibits issuing shares at a discount except in specific cases like sweat equity. This rule ensures financial discipline and prevents misuse of shareholder value. The issuer must complete allotment and refunds within 8 working days after the issue closes. Timely processing is critical to maintaining investor confidence. Delays in allotment or refunds can lead to financial losses and dissatisfaction among shareholders. Therefore, strict timelines are essential for smooth operations. If the issuer fails to allot shares or refund money within the specified time frame, they must pay interest at 15% per annum. This acts as a penalty and discourages delays. It also ensures that shareholders are compensated for the time their funds remain blocked, thereby protecting investor interests. Even after the issue is completed, the issuer remains responsible until shares are credited or refunds are processed. The stock exchange must monitor investor grievances and ensure timely resolution. Additionally, underwriters must fulfill their obligations in case of undersubscription. These measures ensure transparency, accountability, and smooth functioning of the entire rights issue process. Moonses and Management Consultants LLP, a trusted partner for SEZ and IFSC excellence. A pioneer in establishing SEZ and IFSC units within GIFT City and India, delivering end-to-end IFSC setup. Operational support and handling complaints, risk management renowned for deep expertise in regulatory approvals, capital markets, fund management, insurance, finance company, foreign university BAT, and ancillary regulations, and fintech, expertise in customs clearance for aircraft and ship procurement, leasing, GST, DSPF, IFSCA comprehensive support covering registration, reporting, and regulatory transitions, ensuring ring fencing, transparency, and global compliance standards. Join our network, scan the QR codes below to stay connected with us.